everybody. Thank you for joining us today. I appreciate your time. I apologize. Not only are we going to talk about E1 visas today, but unfortunately, you're also going to get some coughing in the background. I'm a little bit under the weather, so I apologize in advance. So, what do I want to talk about today? I want to talk about navigating the E1 visa process as a Canadian speaker. So the key takeaways that I'm hoping for from today's webinar are understanding some of the advantages of an E1 visa, understanding what the eligibility requirements are, what the application process and the key documents and evidence you're likely to need for an E1 visa application, and potential strategies for building a U.S. Canada speaking portfolio that supports an e-visa application, or if you're not there, what are potential alternatives to consider? So some of the advantages to an E1. First of all, an E1 visa can actually be approved for up to a 5-year period. And the application fee is pretty small as opposed to other categories. And that 5-year approval gives you a lot of flexibility. Again, it is for up to a 5-year period. Not only that, but E1s are more generally viewed favorably when the consular officers are reviewing the application, or when you're trying to enter with your E1 visa, as opposed to keeping in mind, wait, am I allowed to come in and do this? Their CBP officers are often looking at, what are you doing? You never know who you're going to cross on what kind of day. They also give you the ability to have consistent and reliable entries into the US for your business activities. So if you're coming in, am I allowed to do this? Am I not allowed to do this? Is this okay? Am I walking a fine line? Do I need to pay attention exactly to what I'm saying? As opposed to, I'm coming in for a workshop. I have a speaking engagement. I'm meeting a client. Very simple, a lot of flexibility, which leads us to the last point, which is that you can have a wider scope of permissible activity. So let's just say you are really focusing on your speaking right now, or your consulting. And then as time goes on and your brand exposure is increasing in the North American market in the US, you're given the opportunity to maybe have a workshop, or you want to do podcasts, or you want to do consulting agreements or coaching agreements. You have the ability to do so under the umbrella of your E1, depending on how you've chosen to structure. So what are the requirements of an E1 visa? So one, there has to be a qualifying treaty in place in between US and the foreign country. In your case, it would be Canada. There is a qualifying treaty. Two, you have to possess the treaty country nationality. So a treaty trader can either be an individual itself. So some professional speakers choose to just operate as a sole proprietor. They may or may not also have a business license because they're doing a DBA, or they have a company. Either way, the ultimate idea is to show that if it's an individual, they're a Canadian citizen, or if it's a company, we have to trace the ownership all the way up to the ultimate individual owners and show it's at least 50% Canadian citizenship. It's not a matter of residing in Canada. We're looking completely at your citizenship. You can have other nationalities as well. So if you're a dual Canadian, Australian individual, that doesn't stop you from qualifying, but that's what we're looking at. I'm a big fan of having visual aids for the consulate. They look at so many of these, and when they have complicated patterns, writing everything out is fine, but I think a picture tells 1,000 words, and putting in models like these really help them understand where the ownership is, what we're doing to identify it. This is a tricky part. The treaty trader must be engaged in substantial international trade, principally with the US. This is where all the meat of the work and all the hard part comes in. So first of all, is there international trade? So international trade, put simply, is there something coming south of the border, and is there something going north of the border? So for most of the professional speakers, they are providing speaking engagements to US customers. In return, US customers are paying the professional speaker in Canada. Is the international trade principally with the US? In that case, what we're looking at is, if I look at all your transactions over the last year, let's just say, and then I divvy them up between domestic and international, is the majority of your international trade with the US. So for example, if you happen to do speaking engagements in US, Canada, and Europe, And when I look at your European and US engagements, are those primarily US or primarily European? If they are equal, then you won't qualify for the E1. But if the US is a vast majority and you randomly have a European, Australian one come in, that's okay. Then they want to know, is a trade continuous and systematic? So did you just have one amazing agreement for a speaking engagement for $20,000 for one transaction? Or did you have two of them for $15,000? Or did you have 10 transactions for 30,000? They want to see the continuous and systematic. They don't want to see just one with the high volume. I'm sorry, with the high value. They want to see that it is spread out, it is continuous. So even if it's a lower amount. So if I was going to look at two, I'd rather have 10 at 30,000, 10 transactions with the total value of 30,000 as opposed to two transactions for a value of 30,000. Which brings us to the question of, is the trade substantial? So unfortunately, this is more of an art than a science. There's no magic number that says, yep, in order for the trade to be substantial, you need to have at least 12 transactions that are at least 5,000 each over the period of 1 year. There's no such thing. So when you're looking at these, it's kind of stepping back and evaluating the whole picture. So can you see, hey, this individual has been speaking in Canada for a long time and they have lots of Canadian transactions and the US one is just slowly picking up. Or are you seeing they've just done a handful of things in the US so far, but it's enough to keep them pretty busy just because it is a sole proprietor. It's one individual. So you kind of have to take a look at the whole picture to see, do you qualify? And sometimes it really becomes more of a gut instinct and review and knowing kind of what kind of feedback the consulate has given, what they're typically looking for, what they like to see. When the consular officers, when they look at all these requirements, they refer to what's called the Foreign Affairs Manual. That's their policy guidance that they're working off of. It confirms that the trade has to be a continuous flow, but there is a provision in there that the smaller businessman shouldn't be precluded just because they have a smaller smaller dollar value associated with that. So in some of my smaller cases where I do have individual speakers, I'll let them know, like, well, yes, we're not talking of hundreds of thousands of dollars. We're talking of less monetary value, but this is a smaller businessman, and look at the trade going on between the US and Canada, but also look at what's happening domestically as well sometimes. The other part of this is kind of cool, and I've been able to use successfully in the past, is the existing trade. So there's two ways to show trade. One, you've either been doing it. So here's proof of invoices I've issued, and this is the stuff I've already done. Here's a summary. And or a combination of, this is what I've already done, but then this is what I have contracts that I'm committed to do. So according to the Foreign Affairs Manual, existing trade can also be supported by binding executed contracts that call for the immediate and ongoing exchange of goods or services. So in that way, if you have a handful of transactions you've completed, and then let's say you now, because of those transactions, you've got consulting agreements or coaching agreements signed up where these individuals have an agreement with you for a period of 1 year. They're going to pay you a monthly retainer of XYZ dollars. That is a trade. That's trade we can include in a potential e-visa application. Now, I've also done this in scenarios where and we've done them for consulting purposes. I have had one time when the consulate pushed back when the individual only had one client. I like it when there's multiple clients, but I have done ones with only one client when the value was higher and it was a 5-year contract. So again, this becomes more of the art conversation than the science. If you are going to use a trade of services to qualify for an E1, they want to make sure this isn't just something you're coming up with haphazardly. Like, this is your business model. This is what you've been doing. So it kind of goes back to saying, hey, what do you do? What's your background? What makes you qualified to provide this service? Why should you, or why would others want to hire you to provide this service? So it can't just be an ancillary accommodation of oh, this is primarily what we do. Oh, we're just going to add in kind of speaking engagements on the side. That really wouldn't work for the E1 visa. So again, going back to visual aids and kind of drawing pictures for the consulate, it's a matter of, what kind of picture do you want to draw for them? Do you want to show them? Sometimes it's a matter of, hey, Look, I didn't charge them anything. I chose to do these activities pro bono, or I did them for an extremely low value. Having said that, my normal value, had I chosen to charge them my full amount, would have been a higher amount. So I have presented these that way. We're being factually accurate of what was or was not charged, but at the same time explaining, look, just like any other business, we chose to reduce our prices for branding purposes, entering the market, market exposure, etc. And then same thing here. So just kind of laying out different ways of showing what's already been completed and then what's already been scheduled, what's anticipated to be completed. So for some individuals, I like to also include information about, look, these are all the pending proposals that are out there right now. This is what we're expecting to get in or what we're hoping to get in. We've got a lot going on. There's some are in negotiation phases. There are proposals out for many. So again, back to the whole picture. So the fourth requirement is that the treaty trader applicant must possess the intent to depart the U.S. upon termination of their status. Put another way, it doesn't lead to a green card. It doesn't let you live here permanently. The E1 can be approved, like I said, in up to 5-year increments, and it can be renewed as long as you're continuing to engage in that trade. And there's no maximum time amount associated with it, but it's not something that lets you get to a green card and have the full-time ability to be here. Which leads to kind of a gray area, depending on who you'll ask. Can you live in the US full-time with an E1 visa as a professional speaker? I will tell you, the whole idea behind the E1 is that there's trade, that there's something going south of the border, north of the border. There's something moving. I think when you have an individual, a sole proprietor, or even if there's a company, but it's only one individual, parked here in the US, speaking with US clients, maybe intermittently traveling back to Canada, I don't think it's out of the question for the consulate to look and say, where's the trade? You're here, you're living here. I'm not really seeing what the trade is. Now, what happens is if you're approved for an E1 visa, while the visa is good for a 5-year period, you're actually allowed to live in the US technically for up to a 2-year. You're issued an I-94. The problem is whether it's US Customs and Border Protection or the consulate might look at you and say, yeah, I don't really see how you continued the trade or how do you still qualify? So my general recommendation is that's not something you should plan on doing. Now, are you limited? If you just have a gajillion US speaking engagements and you're here every other week, I think that's fine. You're going back and forth, that's okay. But the idea of just moving lock, stock, and barrel down here, not so much. The last requirement for anyone is that the applicant has to either be the treaty trader or be an executive, supervisory, or essential employee. So as a professional speaker, you likely are the treaty trader. You're the owner, majority owner, et cetera. You're the principal. So you're good for that. Now, however, ideally your business is going to grow. And so one of the clients I had done an E1 for several years ago, her business has only expanded. She's only hired more individuals, but now she's looking at getting e-visas for those individuals working for her because they're offering consulting and coaching. The nice part is those individuals can get an e-visa under her e-visa umbrella that we got for her company as either executive or essential employees, basically saying that either they're managerial in capacity and they need to enter in furtherance of the company's trade activities, or they're essential. So for example, they're the ones providing some of the consulting services. So they need to enter in furtherance of the company's trade activities. Okay, so you've determined that you can qualify for an E1 and you want to apply. So what's the process look like? So once your E1 visa application packet is ready to go, including completing the online form, paying the visa fee, etc., you actually have to email it to the U.S. consulate in Toronto. And while there are consulates throughout Canada, Toronto is the only one with jurisdiction over new applications or renewals. You have to go to Toronto, no ifs and or buts. The consulate also has very strict instructions they lay out in terms of documents. So you can only submit up to a 50-page document, no more than 20 megabytes in size, and it needs to be a single file. They indicate they want ABC under tab A, ABC under tab B, etc. So you want to strictly follow their requirements, or they'll say thanks, but no thanks, try again. Once you email the packet to the consulate, in a few weeks, I'll usually get back to you and they say, okay, everything looks good. Go ahead and schedule an appointment. This is not an approval. This does not mean that the interview is just a formality. It just means they've reviewed it. Nothing is glaring. So they're ready to go ahead and talk to you in person about the application. At this point, they can also issue what's called a request for information, an RFI, where they're just saying, look, we just need a little bit more. We don't necessarily get this. So can you explain? Can you give us more, etc. Once you do, then they'll review and then they'll get back to you and say, okay, you can schedule an appointment. Once you're allowed to schedule, you can hop onto their website, schedule an appointment, the first available one that works for you. When you go to your appointment, at the end of it, usually the appointment's no more than 3 to 5 minutes at the window at the consulate. They're very quick. The consular officers are very nice. Sometimes it's more like having a conversation than actually having a consular interview. And for our clients that we work with, we always do a prep call in advance of the interview just to make sure, hey, remember what the requirements are. Remember how you qualify. Let's just kind of go over everything and make sure you're all set. At the end of the interview, you should know whether or not you've been approved. Leaving your passport there is a big clue that it's going in the right direction. And I always remind my clients, if you're not sure, it's okay to say, what happens next? At the end, if the visa is approved, the consulate keeps the passport. And about 2 weeks, 1 to 2 weeks later, you'll get your passport back with visa. Once you have that, the first entry you have into the U.S., you need to be prepared to enter through go through secondary inspection so you can be admitted in E status. And then if you have a trusted traveler program, Nexus, etc., you do have to update that so that you can enter an E using your Nexus. Sorry. So working towards an E1 when you don't have to trade yet, what do you do? Because well, obviously the key requirement here is substantial international trade. So one of the things coming out of COVID, people were able to benefit from was all the virtual engagements. But one thing I tell clients who still, who aren't there yet can you reach out to clients that might still be interested in virtual engagements? You're not worried about trying to come in to do it. You can charge what fees you want as long as the client's willing to pay it. And that's a transaction that you can count for purposes of the E, because again, you're providing the services. You just didn't physically enter the US to provide those services. Pro bono is another one. So we'll talk about entering as a business visitor here shortly. But is that something you're willing to consider, again, for brand marketing exposure purposes? Obviously, I don't want to tell you how to run your business model, but sometimes doing a couple of those kind of helps put the numbers together. And again, what I do is I'll say, yes, we did a pro bono. However, had I actually charged, it would have been ABC value. The other nice idea is if you can do consulting or coaching agreements, again, if that falls under your business model. So if you can get a retainer agreement or a contract signed for even a 1 to 2 year period with a client that calls for a monthly retainer or monthly number of hours for XYZ dollars per hour, you can calculate that and you can use that as part of a trade with multiple clients. Sometimes it's a mix of virtual, pro bono, consulting agreements, etc. The other thing you may recall, we talked about executed binding contracts being counted for trade. Well, what if you are able to schedule contracts that are for 5 to 6 months plus out? And then maybe also obtain some letters of intent or interest to show, look, yeah, I've just done this and this so far, but I have these 8 transactions scheduled over the next 6 to 12 months that are valid, that are at a value of $40,000, and I need a visa to come in and do that. Having them that far out puts you in a position of having time to apply and get through the consulate. It is a little risky, obviously, because if for some reason the visa doesn't come through, you are not going to be able to come in to meet that contractual obligation. But and that's a strategy potentially as well. When somebody doesn't actually have a lot of already existing transactions, or they only have a few, the other thing I do like to do is show evidence that others are interested in procuring their services, or that they're looking at them, or letters of interest, or pending proposals. Again, just to kind of show, look, this isn't just on haphazard. It's almost like going to a bank and wanting a loan, but you're really going to the consular officer asking for a visa with the same idea. Look, I have a history of doing this. I'm set up to do this. That's what I'm looking to do. The other category, another option is, do we need to have a 2-step strategy here? Do we need to consider another non-immigrant category called an O1A? And then an E1, is that going to set us up better? And I'll talk about an O1A here in a minute. The last thing I will warn, and this hasn't happened in a while, but used to be, we had a lot of individuals coming to us with denied TNs as management consultants. Somehow they'd gotten approved sporadically, or they were just outright denied. And they were coming in to provide speaking services as management consultants. That category really doesn't work for professional speakers. CBP has really cracked down on that. So the idea of trying to obtain that is likely slim to none and probably end up with more trouble than you want as a TN. So an O1A. So I'm going to tell you my story first. So I had a client came to me and she wanted to start doing speaking engagements, but that wasn't really her background. She was heavy in music and she'd been on TV and she'd had articles written about her, but she really hadn't done the speaking engagements. So, and we didn't have any transactions, we didn't have any trade we could line up. And that was an individual we had to do this two-step strategy for. So I proposed we do an O1A for her, which we have done, and she has the O1, and once her O1 expires, we're going to look at the E1. But the cool part about her O1 was we had to figure out a way to tie her field in. How do we explain what she does and why she's so good at it? And O1A is an individual who's of extraordinary ability in their field. The fun part is picking their field. How do you identify an individual's field? So with her, I chose the field of youth emotional empowerment, and that she chose to deliver her message through song, through storytelling, and through speaking. It was a mix of how she chose to deliver her message. Once we identified her field, then we were able to pull in all her background and evidence. So she had articles written about her. She had written articles. She'd received 2 Juno awards. So we were able to go through the statutory criteria and see how she qualified. And we ended up having her work with a speakers bureau. She reached out, used her connections, signed up with the speakers bureau. And I know individuals are sometimes hesitant to do that just because of obviously the lack of control and having to give up some of that. But with the O1, there's some benefits to the speakers bureau in terms of being able to actually get started. So with the O1, the Speakers Bureau can act as an agent, or rather as a petitioner. You can look for an agent, but what USCIS, the agency that adjudicates these, sometimes does is, well, the agent says you have these 4 potential gigs lined up. Okay, well, this is only covering a 3-month period. Okay, how about I just give you an O1 for 3 months because that's all you've signed up for. That's all that's committed. With the Speakers Bureau, we're often able to say, look, we've been doing this for a while, et cetera, et cetera. We have proposals out for XYZ, these 6 engagements. We have another set of proposals out for another 5 or 6 engagements, and we anticipate a lot more. So with the lady I was just talking about, we did do the Speakers Bureau. We were able to get a 3-year O1 approval, which was fantastic. The O1, the reason that one, besides the cost and time and lack of control with the O1, is the time to prepare for it. So in O1, some of the prep time is often 3 to 4 months, just because it's heavily dependent on obtaining reference letters. And it's not about how amazing you are and how great you are to work with and how nice you are, but it's about how you meet the statutory criteria. So there had to be very specific language in there, and USCIS is notoriously difficult with these applications. So you can file with USCIS. And if approved, it can be approved for up to a 3-year period, depending on what you're able to submit with your application. If the O1 is approved, then as a Canadian, you're able to show up at the border with your O1 approval notice, and you'll be admitted in O1 status. It lets you live here full time if you choose to do so. And at a later date, when your O1 set to expire, you can go to the consulate and explain, look, this is my business model. It used to be I was working through the Speakers Bureau and I had all these engagements. However, I'm no longer working with the Speakers Bureau. I'm going to be doing this way, or I will choose whatever you choose to do, but I want an e-visa instead, so I'll be pursuing it this way. So it's a matter of explaining your plans to the consulate. So entering for speaking engagements as a business visitor. So always remember when you're when you show up at the border and you show your passport and U.S. Customs says, hey, what's the purpose of your visit? When you tell them, you're either being admitted as a business visitor or visitor for pleasure. business visitor entries, pleasure entries are always reliant on CBP's discretion. Sometimes it's a matter of what kind of officer you get, and sometimes what kind of mood they're in, and whether or not, honestly, they believe you and they think you're really going to do what you're coming in for. So if you are allowed to come in to enter as in B1 status as a business visitor for a speaking engagement if you are not going to receive any remuneration from the U.S. source other than expenses incidental. So travel, lodging, meals, that's it. No compensation, not even a pro bono, not a reduced cost, etc. So you are. Now, is CBP always going to concur with that? Not necessarily. So that becomes a little iffy situation because the last thing you want is to make a commitment to show up for a keynote speaking engagement, and the next thing you know, you're not going to make it in. Honorariums are allowed in certain very specific circumstances that may or may not apply to most individuals, but I've laid those out there. But it's basically that the activity, you can accept the honorarium and there's no minimum or maximum on that one, and incidentals. If the activities are not going to last for more than 9 days, which I don't think anybody would say, but the payment has to be offered by an institution or organization as defined. And that one is generally a nonprofit research organization, which is defined, a governmental research organization, which if you Google some of these phrases, there's some very specific agencies that fall under this, or an institution of higher education. Typically, you're looking at colleges, et cetera. And then, or they're related or affiliated nonprofit entity. I'd be careful of trying to use this just because you need to look at the definitions to actually see if they truly qualify. And obviously the honorarium has to be for services conducted for the benefit. This really is meant for guest lecturers, speakers, et cetera, guest teaching. It's not really meant for professional speaking, but you can use it if you meet those requirements, depending on where you're going in to provide those services. Okay, well, that actually took a lot less time than I expected. So hopefully I was able to use your time wisely and give you a lot of information that you can take away that hopefully gives you an idea of how to further set yourself up. If you are interested in speaking further about it, feel free to reach out. Do we have any questions at all, Claire, or?
I don't see any questions, but if anyone would like to type questions in the chat, feel free. Maybe we'll give that a minute and see if we get any.
Okay, thank you.
Oh, we just got one. So asking, I'm a bit confused on how they want to see U.S. income prior to receiving an E1 visa as a Canadian.
It's a lovely chicken and the egg conversation because you're not allowed to come in and do this until you actually have permission to do so. And then you don't qualify for the E1 visa until you do. I don't really have a brilliant answer to this because it is forever confusing, which is why you have those, can you do as a B? Can you do the virtual engagements? Do you do the O1 first? Do you qualify for another category first and have to build it up that way? It really is a confusing scenario, and it's set up for almost individuals to be like, so you expect me to do something that's not allowed in order to qualify for the visa that is allowed. I wish I had a better answer, but it really is a chicken and the egg scenario, and there's no good answer here.
Awesome, thank you. I'm not seeing any other questions. Let's see. Oh, here's one. Working with the Speakers Bureau, can they get you an E1 visa easier than an individual applying?
So the Speakers Bureau, if it was a Canadian Speakers Bureau, potentially, but they usually are probably not going to want to, unless they have their own E1 visa. So they have already gone through and established that they do trade with the US. It wouldn't really work. If it's a US Speakers Bureau, they won't qualify because remember, the E requires Canadian ownership and nationality of the entity doing the trade. Does that answer the question?
We did get another one coming in. So And yes, that did answer the question. But another quick one. So what's the cost associated with applying for an E1 visa?
So the legal fees are going to depend on the attorney you work with. Then the government application fees are actually, you have to pay your visa application fee, which is $305. Canada just did away with, our treaty just did away with the reciprocity fee. So honestly, let's just say you're comfortable and you can do this yourself. That would be it, $315. My fees are separate, but I work on a flat fee basis. So usually what happens is I have a conversation to say, okay, this is, and I get a handle on what's involved in working on your case. And then I let you know what my fees are.
Awesome. All right. I think that was the last question. You're all set.
Well, thank you again for your time. I hope this was informational. And thank you, Claire, so much for taking care of everything.